Hi, my name is David Barnett from the law offices of Barnett, Lerner Karsen, PA. We're a law firm handling defense-based act claims for civilians injured around the world pursuant to any type of government contract or construction project outside the United States. Oftentimes, when we represent injured workers, the first step that we must establish is whether or not we can establish or prove that an injured worker has established or created a prima facie case. In other words, establishing that they sustained an injury in the course and scope of their employment, or that working conditions existed which caused, aggravated, or accelerated an injury or condition which necessitates both the need for medical care as well as any type of subsequent disability. Section 20 of the Longshore and Harbor Workers' Compensation Act is the section that we look to, and that provides a benefit to the injured worker. Basically, it provides that there's a presumption in favor of the injured worker that they notify their employer timely. The presumption is also in favor of the injured worker that their injury comes within the provisions of the Act. The presumption also favors an injured worker that they did not intend to injure or kill themselves. And finally, the presumptions also are in favor of the injured worker that the injured worker did not injure himself solely by his own intoxication. Essentially, these benefit the injured worker in going forward that their claims are covered under the Act. It's the claimant's burden to establish and provide medical evidence to substantiate that they were hurt and that they were subsequently in need of care, and in terms of disability, if they're unable to work, entitled to disability or compensation benefits. Once there's competent evidence to substantiate or prove up that an injured worker was injured in the course and scope of employment, then the burden shifts to the employer carrier to provide substantial evidence to rebut the presumption and to show that there's evidence that the injury did not occur in the course and scope of employment, or that the injured worker was not in actuality injured. If the court finds that the employer carrier did rebut the presumption, then the court looks at all the evidence in whole and then weighs the evidence to determine whether or not the claim is covered under the Act, entitling the injured worker to both medical and wage benefits.